Hello everyone, welcome to Lin Daliu IP course. I am Meng Wang, a Chinese lawyer from Lin Daliu Group. Patent invalidation proceedings serve as critical post-grant error correction and check and balance mechanism. They are designed to ensure that patent grants comply with legal requirements and balance the interests of patentees with public interests. In China, any entity or individual that believes a patent was granted in violation of the patent law may file an invalidation petition with the China National Intellectual Property Administration, i.e. CNIPA. In practice, however, malicious practices have emerged. This includes filing petitions under false names, forging signatures, or using strawmen manipulated by competitors to file repeated invalidation challenges. The aim is to disrupt the patentee's normal business operations, increase litigation costs, and even use such petition as leverage in commercial negotiations. In addition, repeated rounds of litigation based on substantially identical grounds and evidence waste administrative resources and impose an undue burden on patentees. To clean up the environment for invalidation proceedings and improve examination efficiency and fairness, CNIPA has added key provisions specifically for invalidation proceedings in the newly revised guidelines for patent examination, which took effect on January 1, 2026. The goal of these changes is clear: to protect the legitimate right to challenge patents while precisely targeting malicious conduct, thereby enhancing the predictability and efficiency of the entire system. Now I'd like to explain these two core changes in detail in two parts. Part 1. Petitions not reflecting true intent shall not be accepted. According to official interpretations, if examiners have reasonable doubts regarding the petitioner's identity or intent during the acceptance stage, they may require the petitioner to verify their identity or submit notarized documents proving their true intent. If such proof cannot be provided, the petition will be rejected outright. Shortly after the new rules took effect, the Patent Re-examination and Invalidation Panel applied this provision for the first time in a high-profile pharmaceutical patent invalidation case. After review, the panel found that the signature on the petition documents was forged, determined that the petition did not reflect the petitioner's true intent, and ultimately decided not to accept it. This case is widely regarded as the first shot in enforcing the new rules, clearly demonstrating the authorities' resolve to crack down on such fraudulent conduct. This provision provides a solid firewall for patentees, especially enterprises holding high-value patents. It effectively blocks harassing challenges with improper motives, significantly reduces the resulting uncertainty and defensive costs, and allows business to focus more securely on innovation and market activities. Part 2. Putting an end to vexatious litigation, strengthening the one-attack principle. The new rules further tighten restrictions on repeated petitions, expanding the application of the one-attack principle from identical grounds and evidence to explicitly cover identical or substantially identical grounds and evidence. The core of the determination is whether the core technical assertions and legal arguments supporting the later petition have already been substantively reviewed and decided in a previous examination decision. For example, if a previous decision has already held that a claim is inventive over a prior art document, a subsequent petition merely alleging that the claim lacks novelty based on the same prior art document will likely be deemed based on substantially identical grounds and evidence. This change brings multiple benefits. First, It significantly strengthens the res judicata effect of invalidation examination decisions, allowing patent status to stabilize more quickly after substantive challenge. Second, it forces all challengers to treat the first attempt as decisive, requiring them to present their strongest and most central combination of grounds and evidence in the first challenge, thereby improving the overall quality of invalidation challenges. Finally, it also helps patentees optimize their allocation of their litigation response resources. This marks that China's patent system is moving toward greater maturity, efficiency, and legal certainty. For global innovators, a thorough understanding and effective use of these new rules are key steps to maximizing the value of intellectual property in the Chinese market. Thank you for your attention. Bye.